My name's RJ McGill. I'm the Senior Manager of Communications here at the American Academy and the editor of the Berlin Journal. I had the privilege of editing Lawrence for the most recent issue. Tonight's Daimler lecture is entitled Aggressive War, Atrocity and the Verbrecherstaat by Lawrence Douglas, who is our Spring 2022 Daimler Fellow. Lawrence, it's an honor to have you here this semester, of course. Should say hello from Dan Benjamin, who's unable to be with us tonight. The American Academy has many reasons to be grateful to Daimler, not least because of the Daimler Berlin Prize, which was endowed in 1999 with the purpose of bringing at least one fellow per year to the Academy from the fields of public affairs, political science, journalism, or the performing arts. Our most recent Daimler Fellows include comparative literature scholar Emily Apter, political scientist Stephen Klein, film scholar Nora Alter, and of course tonight's speaker, who is currently the James J. Grossfeld Professor of Law, Jurisprudence, and Social Thought at Amherst College in Massachusetts. Many of Lawrence's writings explore the complexities of legal responses to state-sponsored crimes against humanity. In his 2000 book, The Memory of Judgment, Making Law and History in the Trials of the Holocaust, he examined the successes and shortcomings of a set of international trials of Nazi war criminals to show how these proceedings changed the way we perceive both the Holocaust and the legal process. Owen Fiss at Yale called the book a worthy successor to Hannah Arendt's Eichmann in Jerusalem, which is rather high praise. Lawrence's 2016 book, The Right, Wrong Man, John Demjanjuk and the Last Great Nazi War Crimes Trial, zeroes in on one of the trials featured in The Memory of Judgment, that of a Ukrainian-born naturalized U.S. citizen and Cleveland auto worker who had been accused of participating in the Nazi genocide. In the years that followed, Demjanjuk was stripped of his American citizenship and sentenced to death by a Jerusalem court, accused of being Ivan the Terrible of Treblinka, a televised trial characterized by dramatic national cathexis. He was later cleared in one of the most notorious cases of mistaken identity in legal history. Lawrence had been sent to cover this trial by Harper's in 2009, and the resulting book became the basis for the popular Netflix documentary, The Devil Next Door. And then there's Lawrence's clairvoyant May 2020 book, Will He Go? Trump and the Looming Election Meltdown in 2020. Here, Lawrence foretells of a closely contested presidential election that would lead to a certain person's refusal to concede his loss, thus exposing the vulnerabilities of the American electoral system, the consequences of which we are obviously still living through. Perhaps it is unsurprising at this point to learn that Lawrence is also the author of two works of darkly humorous fiction. The Catastrophist, an academic comedy of manners, was named Best Book of 2006 by Kirkus and received the Silver Prize in General Fiction at the Independent Publishers Book Awards. And the second fiction book is Vices. The Vices, a rollicking international foray into the moneyed family history of a presumed dead philosopher and art collector, which was named the Best Book of 2011 by New York Magazine and the New Statesman, and a finalist for the 2011 National Jewish Book Award. In addition to his books and many scholarly publications, Lawrence writes regularly for the Times Literary Supplement and The Guardian, among others. One could go on. Before handing the podium to Lawrence, let me just explain quickly the Q&A for those of you are watching over Zoom. Don't use the raise your hand function if you'd like to ask a question later on in the Q&A session. Please just type your question into the chat and we will find it. We've switched up, there are two chairs there, but we've switched up the format tonight. Lawrence will remain at the podium afterwards and take your questions directly. And with that, the floor is yours.
Also, schönen Abend, good evening. Thank you for the very generous introduction, RJ. I'd also like to thank other members of the Academy, Dan, who can't be here tonight, Caitlin for putting things together, for the whole wonderful staff at the American Academy. It has been a pleasure and an honor to be here, and I'm also very grateful to my fellow fellows who have been an incredible source of pleasure and an exciting conversation. I'm going to speak for about 45 minutes tonight. And if I go on, my younger son happens to be here. He's on spring break from college. And I remember I took him to a lecture that I gave in Glasgow when he was only 8 years old. And I also promised to give a relatively short lecture. And then I noticed that when I had run on, he took a pen out, the 8-year-old. He drew a watch on his wrist. And he went like that. So I will try to keep within the proper time frame. And then we will have, I think, abundant time for question and answers. And I'll do my best to answer questions. And if I don't answer them properly, I just ask you not to come up and slap me in the face. And in its March 8th edition, the German news weekly Der Spiegel devoted a remarkable 16 pages to an interview that Spiegel publisher Rudolf Augstein had conducted with the philosopher Karl Jaspers. You can see Augstein on the right, Jaspers, I guess on the left, and Jaspers on the right. The topic was whether the German statute of limitations for the crime of murder should be lengthened. And this hardly seemed to promise a profound discussion between Germany's most prominent publisher and arguably its most prominent living philosopher. And yet the German statute of limitations had emerged as a topic of passionate domestic and international debate. By the terms of the German legal code, the prosecution of every crime at the time was controlled by a statute of limitations, and murder had the longest statute of limitations, but even that was limited to 20 years. And this meant that in 1965, the 20-year statute of limitations on murder prosecutions was about to toll on Nazi-era crimes. So without a statutory extension by the Bundestag, that is the German legislature, the parliament, May 8th, 1965, the 20th anniversary of the end of the war in Europe, well, that would have signaled the end of all Nazi-era prosecutions in the German Federal Republic. And thereafter, German prosecutors, they would have been powerless to bring any charges against any former Nazi for any crime committed during the Third Reich. And as you can probably imagine, this prospect aroused a considerable international outrage. For example, the New York Times, editorialized that, and this is a quote, "permitting men and women who help to perpetrate the greatest crime in history to go unpunished represent a monstrous distortion of justice," end quote. And this is basically how matters stood when Augstein traveled to the Swiss city of Basel to interview the famous philosopher who was then in his 83rd year. Jaspers, during the Third Reich, had been forced to resign his professorship before seeing his work banned altogether. And at the outset of this interview, at the very beginning, Augstein made clear that he really wasn't interested in a technical legal discussion about statutes of limitations. Instead, he asked Jaspers to weigh the matter from what he said was a moral standpoint. And this is how Jaspers began his interview with, how Augstein began his interview with Jaspers. Augstein said, "During the conquest of Jaffa, Napoleon took 3,000 prisoners, and to save on powder and bullets, he had them all bayoneted to death. Many of these captives were in the company of their families, and these families, they too were bayoneted to death. Nevertheless, no one suggested that anyone beside Napoleon should be held responsible for this massacre. By contrast, today, in the case of Nazi crimes, we act as if it's typical and proper to put on trial anyone who may have shot women and children under orders." And Jaspers immediately pushed back against this question from Augstein. And this is what Jaspers said. He said, "Well, don't we need to recognize an essential distinction? History knows many such stories as the one about Napoleon. In this case, the representative of the state, Napoleon, committed a crime, but the state in its essence was not criminal. And then he went on to say, and I'll just say it in English here, the decisive point is to recognize that the Nazi state was a Verbrecherstaat, a criminal state, not a state that happened to commit crimes. So I think one thing that we want to talk about this evening is what does it mean to call a state a Verbrecherstaat, a criminal state? As many of you might know, criminal responsibility typically attaches to individuals, not to entities. But I think that only begins to touch on the kind of the weird quality, kind of the dissonance of Jasper's term. I will try to argue that Western political and legal thought had long been committed to what the British jurist and Nuremberg prosecutor Hartley Shawcross memorably called the, quote, the mystic virtues of the sanctity of state sovereignty, end quote. And from the perspective of this tradition, from this kind of traditional tradition, this traditional position of Western political and legal, the Western political legal tradition, the term Verbrecherstaat, I think it's fair to say it wasn't just discordant, it was something of an oxymoron. Now, to better appreciate the oxymoronic quality of the term, I want to just briefly jump back more than 3 centuries from the time of Jasper's interview. And as some of you, again, from your studies might recall, in his masterpiece of 1651, Leviathan, the English philosopher Thomas Hobbes, not Calvin and Hobbes, who my students sometimes refer to, Hobbes asked his readers to follow him on a daring imaginative journey. Imagine, Hobbes basically asked us, what life would be like in a state of nature, that is, in a place without any institutions of governance. What would such a state of nature look like? And Hobbes's very famous answer was, it would look solitary, poor, nasty, brutish, and short, with the rhetorical emphasis, of course, on the last adjective, short. In a state of nature in which people have imperfect information about resources available to meet their basic needs, folks will not behave as good neighbors, Hobbes predicted. Men, and this is again Hobbes's language, men will act in fear to protect their lives and goods because they will assume that their fellows will be acting in the like manner. So what does it mean? Does that mean that I should simply remain on the lookout for my neighbor's rather covetous glances at my stockpile of muesli, prepared, if necessary, to repulse his aggressions? And the answer is no. Because if rational, my neighbor will not permit any retaliation to his raid on my muesli. He will kill me with a lethal first strike. And to guard against that, I would be wise to launch a preemptive strike and kill him first. Now, under local circumstances, this is entirely rational behavior, but not because people are innately evil, that's not his picture, but because they are rightfully fearful under disorganized conditions of perceived scarcity. And yet when all persons in a state of nature act in this fashion, launching preemptive strikes, well, what they do is they succeed in creating the very evil they most fear, a horrific state of peril and violence that Hobbes simply calls war. Now, I think we need to just pause over what an astonishing claim that is. I think we tend to imagine that peace is our natural state and that war represents its violent disruption. But Hobbes says not so. Hobbes insists that war is our natural state. And peace, by contrast, is an artificial condition that must be created and then vigilantly maintained by a superior force. And that superior force is what we call the state. And the story that emerges from Hobbes is striking because it claims to be irresistible. That is, through an exercise of what I think today we would call social scientific modeling, Hobbes has shown his readers that without a state to pacify us, we would live miserable, violently shortened lives. At the same time, however, Hobbes tells us that the state of nature does not disappear with the advent of the state, with the creation of the state. Instead, the state of nature, it displaces to a different sphere, namely the relation between states. So for Hobbes, sovereigns on the international stage, without any power overawing them, that these sovereigns on the international stage confront each other as persons did in the absence of a sovereign. In the relationship between states, then, the state of nature is no longer just a political imaginary, but it really defines a terrain of actual or potential conflict. So the international stage is a condition of equality in peril, with every sovereign authorized to defend and to advance its interest. Now, I pause on Hobbes because I think we see an early expression of a theory of statehood and sovereignty that in various guises came to dominate Western political and legal thought really through the end of the 19th century. We could even say well into the beginnings of the 20th century. And I call this a theory, though I think we could just as well call it an ideology. Because what we're describing is kind of a rich and at times contradictory system of belief that came to treat, as our Nuremberg prosecutor Hartley Shawcross lamented, that came to treat state actions with a kind of almost near mystic sanctity. And indeed, this ideology came to associate statehood with a unique achievement and expression of Western civilization. So with Western statehood came two foundational prerogatives of the sovereign. In internal matters, states had monopolistic control over the creation and enforcement of their own domestic legal order. So this meant that my legal code applies only over my territory and not over the territory of a neighboring state, because that neighboring state likewise enjoyed a monopoly over its territory. So no sovereign was authorized to pass legal judgment on how a coordinate sovereign exercised its internal police powers over its own legal subjects. In external affairs, in the relationship between nations, all states were understood to be formally equal, that is, endowed with the right to wage war against enemies. And not only was war-making a prerogative of the state, it was exclusively a prerogative of the state. That is, again, with statehood reserved to Western political territorial entities. International law then forbade non-state actors from waging a war, and in fact, this is largely remains true today if you look at the international law of armed conflict. But if we think for a moment, we've also seemingly located a huge defect in the theory that we associate with Hobbes. And this defect was pointed out by the German philosopher Immanuel Kant. As Kant observed, Hobbes' defense of state sovereignty is ultimately a recipe for disaster. And why is it a recipe for disaster? Well, because it simply transfers the risk of being killed by our neighbor to the risk of being killed by a warring modern state. And so from this perspective, it seems utterly bizarre for international law to secure, to protect a sovereign's right to wage war. Shouldn't, after all, international law do just the opposite? Shouldn't law instead seek to aggressively limit state war-making, or perhaps even to just kind of ban it or prohibit it outright? And we find a provocative answer to that point in the work of the neo-Hobbesian Carl Schmitt. Schmitt, as some of you know, was a 20th century German legal theorist whose embrace of Nazism was more than just casual. And I think it's fair to say that Schmitt was something of a pretty nasty piece of work. On the other hand, I think there's sort of no denying his brilliance. And one of the things that Schmitt tried to do is he sought to defend the tradition of Western, he tried to defend this traditional Western system of international law against Kant's critique. So Schmitt actually claimed that by granting each state the reciprocal right to wage war, the traditional system of European international law actually produced less violent and more humane wars. And Schmitt noted, for example, that in the centuries before Hobbes, Christian theologians insisted that wars may only be waged for a just cause. So that sounds nice. You only wage war for a just cause. And yet Schmitt pointed out that this seemingly nice idea simply ended up justifying spectacular atrocities in the name of religious purity. And worse still for Schmitt, were the efforts of pacifists and liberal internationalists in the wake of World War I to criminalize aggressive war. Why? Well, for Schmitt, Kant epitomized the problems with these utopian dreams. Kant believed that the creation of genuine world peace, the pacification of international relations, well, it would require a confederation of peace-loving republican states. And that sounds nice. That sounds a possible ideal. The only problem was that Kant's imagined peaceful confederation could not tolerate any state that sustained itself through aggression. For Kant, such an aggressive state had to, and this is a quote from Kant, it had to, quote, renounce its iniquitous inclination towards other peoples, and it must do so with an official change in political legal form, end quote. Well, what if our aggressive state doesn't want to renounce its iniquitous inclinations and doesn't want to renounce its political legal form? Well, then our Pacific Federation has to use force to make it do so. That is, it must wage war to create peace. And this, according to Schmitt, is no ordinary war over territory or resources. This is, to use the common parlance of today, this is a war of regime change with the goal of obliterating a sovereign political legal form. And for Schmitt, Kant's quest for perpetual peace then simply ends up potentially authorizing wars of annihilation. But then Schmitt had to answer a question of his own, which was, well, how then was international law to respond, let's say, should a Western state engage in truly egregious acts of aggression and atrocity against its neighbors? In a lecture to Nazi jurists in 1937, Schmitt dismissed this question as a ridiculous hypothetical. It was impossible, he argued, for a sovereign European state to ever become, quote, totally criminal, end quote. That is, to become a Verbrecherstaat. Well, so much for Schmitt's predictive powers. The Nazi state, of course, became precisely what Schmitt had considered a practical impossibility. And that Germany, the land of Dichter and Denker, of poets and thinkers, had turned into a Verbrecherstaat, I think it's fair to say it was a shock not only to the traditional Western international law, but to the entire Enlightenment ideology that had rather confidently associated statehood, modernization, industrialization, secularization, it kind of associated all of these with the progress of civilization. So then we need to ask, how did international law respond to the unusual challenge posed by the advent of this Western Verbrecherstaat? And the boldest and I suppose the most interesting response took the form of the Nuremberg Trial. And as I assume all of you probably know, Nuremberg was a collaborative legal exercise of the United States, Great Britain, France, and the Soviet Union. It was, we should bear in mind, the first international criminal trial in human history. And in the dock sat physically 21 major functionaries of the defeated Nazi state. And today Nuremberg is perhaps best known as the first trial to condemn state functionaries for crimes against humanity. As we'll see in a moment, crimes against humanity was not the main charge that was brought against the defendants at Nuremberg. And it's also important to bear in mind that Nuremberg actually wasn't the first trial to pioneer the term, or the first legal proceeding to pioneer the term crimes against humanity. The term found its first official mention 30 years earlier. In a declaration by France, Russia, and Great Britain, explicitly condemning the Turkish massacre of Armenians as crimes against humanity and civilization. Now, what you see here is a contemporaneous representation of the mass atrocities against the Armenians perpetrated by Ottoman Turks, principally between 1915 and 1916, though they actually continued through to the armistice. I think it's fair to say that this representation is full of cliches of Orientalism. It almost looks like a painted scene out of an Indiana Jones movie. And I think it powerfully suggests why, although the Turkish destruction of the Armenians, it did provoke international condemnation, it did not, however, trigger this kind of larger rupture in political and legal thought like Nazi atrocities would. In 1884, before the Armenian, about 30 years before the Armenian slaughter began, James Lorimer published a book called The Institutes of the Law of Nations. And this Lorimer, he was a jurist and a professor at the University of Edinburgh, and he was one of the foremost international lawyers of his day. And his book, you just see kind of like the title page there, it was one of the foremost international, one of the most influential statements on the international law of statehood and sovereignty. And in Laura's, he actually offers a pretty elaborate schema in this book, but in Lorimer's schema, Turkey and China and Japan, they occupied something of a spectral space in international law. So these were not colonies, but they're also not complete sovereigns either. They were, to borrow Lorimer's term, semi-barbarous states and semi-sovereigns. So they were functionally in control of a definite territory, but they were lacking the features associated with full civilization, most notably a tradition of humanistic Christianity. And such semi-sovereigns were not accorded the same right of non-intervention in their internal affairs that we've already noted that was accorded Western sovereign states. And for example, even today, I think we think of the term humanitarian intervention as practices meant to defend human rights writ large. But in earlier context, and I think this is something that actually Lauren Benton mentioned last week, that this term, humanitarian intervention, in an earlier context, it actually denoted the right of European states to protect Christians under semi-barbarous control, particularly, for example, under Ottoman control. Indeed, when France, Russia, and Britain first issued their declaration condemning Turkey for these atrocities, the original language proposed by the Russian foreign minister called the atrocities not crimes against humanity, but rather crimes against Christianity and civilization. So the idea that a semi-sovereign, semi-civilized state would commit mass atrocities against a minority Christian population represented less a challenge or a refutation of the mystic sanctity of the state than a confirmation of its basic tenet, being that only in Western Europe had statehood and civilization become firmly wedded into a normative system of order. German mass atrocities created then the kind of seismic shock to the system that Ottoman Turkey had not. And yet crimes against humanity was, as I just mentioned a moment ago, crimes against humanity was not the central charge that was brought against Nazis on trial at Nuremberg. And Jaspers, it turns out, was not the first thinker to characterize Nazi Germany as a criminal state. That distinction actually goes to a Soviet jurist named Aaron Treinen. And Trainin, who was Jewish, in 1944, he published a short book on Nazi criminality. And again, this is 44, so if we think about it, this was a year after the struggle against Hitler's Germany had taken a decisive turn with the Soviet capture of the remnants of Pauley's Sixth Army at Stalingrad. And in this book, Trainin characterized the Nazi state as criminal in its essence. But he did not identify the Nazis' already well-documented extermination of his fellow Jews as the regime's central crime. Instead, Trainin insisted that what made Nazi Germany a Verbrecherstaat was its aggression, namely its unprovoked attack on its neighbors, most notably in its scorched earth invasion of the Soviet Union. And Nuremberg ended up representing, I think we can say, the triumph of the Trainin perspective, because at Nuremberg, aggression ended up defining the paradigmatic crime of the Verbrecherstaat. So here is an excerpt from the charter of the Nuremberg Tribunal, and you can even see that crimes against peace is given pride of place. So it kind of emphasizes that this was meant to be the gravamen, or the main charge that was brought against the defendants by the prosecution. So under the rubric of what it called crimes against peace, Nuremberg treated aggressive war, that is the unwarranted use of military force, as the core crime in international law. And in its final judgment, the Nuremberg justices, the judges, held, and this is just a quote that I'll read from their judgment, it said, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from the other war crimes in that it contains within itself the accumulated evil of the whole." So the reasoning was that, and at some level it makes perfect sense. The reasoning was that without a war of aggression, there would have been no war crimes and no crimes against humanity. And the tribunal actually even went one step further. And they concluded that their jurisdiction over this, the last one here, of crimes against humanity, they concluded that their jurisdiction over crimes against humanity was limited to those that could be linked to the Nazis' war of aggression. So as a practical matter, this didn't really change the outcome of the trial, since the Nazis' worst crimes against humanity were committed in the years after Germany attacked Poland on September 1st, 1939. But as a practical, as a real-world matter, it did mean that there were certain acts that the tribunal simply could not pass judgment on. So, for example, the state-organized nationwide pogrom of November 8th, 1938, and the systematic killing of people suffering from physical, or perceived to be suffering from physical and mental disabilities. These acts, the court concluded, were unrelated to the Nazis' crimes against peace, and therefore it fell, these acts just fell out of the jurisdiction of the court. Now, we might want to ask ourselves, well, why did they limit their jurisdiction over crimes against humanity to only those crimes against humanity that you could link to crimes against peace? And we've already observed that that sovereign prerogative had long insulated a state's treatment of its own subjects from external legal scrutiny. And at Nuremberg, the U.S. and Soviet teams were particularly wary about the consequences of radically jettisoning this traditional principle. So the chief American prosecutor, who was on leave from his position on the U.S. Supreme Court, Robert Jackson said the following. He said, "We have some regrettable circumstances in our own country in which minorities are unfairly treated." And the point was that the idea of a Southern governor who might have to answer before a future international court for perhaps enforcing Jim Crow laws, that was a prospect that Jackson was not about to authorize at Nuremberg. And so by insisting that crimes against humanity only became international crimes when linked to aggressive war, Nuremberg really did not aggressively reject what we have described as the sovereign's internal prerogative. Rather, we can say it relaxed its application to deal with the anomalous case of an aggressing Verbrecherstaat, criminal state. And I think we can say much the same about Nuremberg's criminalization of aggressive war. So on one level, it looks like a pretty astonishing legal breakthrough to criminalize the waging of war. A mere quarter century earlier, Allied jurists had considered trying Kaiser Wilhelm II for starting World War I. But they ultimately rejected the idea, not because they thought Kaiser was innocent, but because they concluded, and this is a quote, "A war of aggression may not be considered as an act directly contrary to law," end quote. Now, by the time of the Nuremberg trial, things obviously had changed. And I don't have really time right now to go into how this happened or to explore the legal controversies that it aroused. But at least I think we can say that Nuremberg appeared to represent the great culminary success of an effort to turn aggressive war from what had been the sine qua non of sovereign prerogative, and to flip it around and to turn it into the foundational crime of an emerging international legal order. And yet here again we encounter, I think, an important qualification. Because although Nuremberg provided a clear definition of war crimes and crimes against humanity, so if you read like B and C, they give pretty clear definitions of things like extermination, enslavement, deportation, ill treatment, deportation, slave labor. If you look at the definition of crimes against peace, well, you see there is no definition of crimes against peace, really. They kind of left crimes against peace relatively undefined. Now, I think the Nuremberg Tribunal could afford to overlook this imprecision because however you defined aggressive war, Nazi Germany was going to satisfy it. So it didn't really matter that they arrived at some satisfactory definition at the time. In fact, I think it was fair to say that Nazi aggression was so extreme that it led to a blurring of categories at Nuremberg. So if you look, for example, at Hitler's invasion of the Soviet Union, which for this Aron Treinen, remember that was his paradigmatic case of criminal aggression. Well, obviously it was clearly unprovoked. But Hitler's Ostkrieg, the war in the East, it also really erased the distinction between aggression on the one hand and atrocity on the other. Because this Ostkrieg really was a Vernichtungskrieg. It was a war of annihilation. And in this kind of war, atrocities did not simply follow in the wake of the advance of the Wehrmacht, but it was the very means of waging war itself. And so I think it's fair to say that the horrific quality of Nazi aggression worked to conceal the instabilities within Nuremberg's concept of crimes against peace. But these instabilities, they surfaced soon enough. As some of you no doubt know, Nuremberg wasn't the only international trial that was staged after World War II. There was a companion case to Nuremberg that took place in Tokyo in the Far East that saw several Japanese statesmen and generals likewise convicted of waging a war of aggression. But lodged against these convictions was a vehement 700-page dissent that was penned by an Indian judge named Radhabinod Pal. And Pal condemned crimes against peace as a law concocted by Western jurists to entrench a status quo that had been established. Well, how had that status quo been established? Well, it had been established by centuries of Western aggression. So for Pal, the criminalization of aggression was not a means for advancing global peace, but rather it delivered a legal weapon in his mind to punish non-Westerners for challenging a globe that, after all, had been carved up by centuries of Western war. And the 1950s, I think, witnessed a further erosion of Nuremberg's effort to make aggression the hallmark of international criminal law. In the early 1950s, the International Law Commission, it was a body that was convened by the United Nations. This commission was tasked with solving the problem that had kind of bedeviled the Nuremberg Tribunal. That is, they were tasked with trying to define a war of aggression. And yet this task proved overwhelming to the members of this International Law Commission. They asked questions such as, did a colonial war of liberation constitute aggression? What about fomenting civil strife in another country? Did that constitute aggression? And so vexing was this effort for the jurists that these international jurists, they found themselves just arguing about whether a definition was even possible or necessary, and then they just gave up. And as the Cold War continued, neither the U.S. nor the Soviet Union was willing to let some now ill-defined crime be used to settle scores with their foreign policy. And I think we can even say that tellingly, after the collapse of the Soviet Union, when the United Nations establishes two international criminal tribunals to deal with crimes in the former Yugoslavia and in the crimes in Rwanda, neither of these tribunals even had aggression as a chargeable crime. And even the Iraqi Special Tribunal that tried Saddam Hussein did not charge the Iraqi dictator with aggression, even though it really was Saddam's unprovoked invasion of Kuwait, which obviously triggered the UN's deployment of international force. And if we look all the way to today, to the International Criminal Court, and of course this is the permanent tribunal that is in The Hague, which is tasked with dealing with the most basic international crimes, things really don't look any better. It really wasn't until 5 years ago that the member states of the International Criminal Court, having finally agreed on a definition about 10 years ago, that they even activated the jurisdiction of the court over this crime. And yet the court's jurisdiction over the crime of aggression is right now, it's so narrowly defined that even if through some kind of transport device, Vladimir Putin were to magically materialize in the Netherlands, the International Criminal Court would not have the authority to try him for the invasion of Ukraine, that is, for aggressive war. So it seems then that the Nuremberg wager, that is to make aggression the centerpiece of the emerging system of international criminal law, that has conspicuously failed. And far from the supreme international crime, seems that aggression has basically largely passed very quickly into legal irrelevance. And if we had to ask, well, what then is the international crime that now carries the banner of supreme? And that is clearly genocide. Genocide was the term that Raphael Lemkin was a Polish Jewish jurist and refugee who at the time was working for the U.S. War Department. He coined this term in 1944. That is, in the very same year that the Soviet jurist Arnon Trenin was talking about the Nazi attack on the Soviet Union as the criminal aggression. In 1944, Lemkin published a book called Axis Rule in Occupied Europe, and what he did is he wedded the ancient Greek word for group, genos, to the Latin word for killing, side, to describe the Jews, the experience of Jews in Nazi-occupied Europe. And what Lemkin was after was to denote something distinct from crimes against humanity. So Lemkin was determined to distinguish between the targeted extermination of groups, qua groups. That's what he understood genocide to mean. He was interested in distinguishing that from, let's say, the indiscriminate bombing of civilian targets, which is what we understand, for example, as a paradigmatic example of a crime against humanity. And in 1948, basically just a few years after he coined the term, the UN recognized genocide as an international crime separate and independent from crimes against humanity. And this framing of the UN Genocide Convention in 1948, it marked a really important conceptual shift away from Nuremberg's focus on aggression. And I'll just want to quote briefly, I'm going to read from just the Article 1 from the Genocide Convention. So it recognized genocide as an international crime, whether committed in time of peace or in time of war, in which the convention's signatories pledge to prevent and to punish. Now, these are pretty remarkable words, because we've already seen at Nuremberg that crimes against humanity were considered international crimes only if linked to a war of aggression. And the Genocide Convention, it obviously rejected this understanding. Acts committed in times of peace, that is, acts that might be entirely internal to a state, can now constitute, according to the Genocide Convention, international crimes. And moreover, Nuremberg implied that international law had now criminalized all state war-making unless deployed in self-defense or deployed in response to another state's criminal aggression. And that's it. Those are the only occasions for waging war, self-defense or responding to another state's criminal aggression. The Genocide Convention now suddenly seems to introduce a new justification, authorizing or even obligating the use of force to intervene against the state to prevent genocide against that state's own legal subjects. That is, it now seems to revive this notion of humanitarian intervention that we talked about a bit earlier. A second very important, I think, conceptual move away from Nuremberg came in the form of the Jerusalem trial of Adolf Eichmann. So Eichmann, as many as you know, he had been a lieutenant colonel in the SS, and he had been responsible for overseeing the deportation of more than 1 million Jews to SS killing centers. And his trial, which received huge international attention, it served to decouple the crimes of the Holocaust from Nazi war-making. And in doing so, I think the Eichmann trial worked to transform global perspectives and global perceptions of Nazi extermination. That is, the Nuremberg understanding saw the exterminatory actions of the Nazi state as one particularly horrific aspect of the Second World War. But now the Eichmann trial framed an understanding of these crimes as basically a crime sui generis, that is, one whose organization, whose logic and goals could not be reduced to the logic of aggression. If we shift our attention to more recent mass crimes, the killing fields of the Khmer Rouge, or the ethnic cleansing in the Balkans, or the massacre of Rwandan Tutsis, it's again acts of mass atrocity, not aggression, that constitute the core crimes of international law. And it's these crimes that occupied the caseload of the UN Yugoslavia Tribunal and the Rwanda Tribunal, and have been, in the first 20 years of its existence, the exclusive focus of the cases before the International Criminal Court in The Hague. And I think this is basically where matters stood until February 24th. The Russian invasion of Ukraine has suddenly revived interest in Nuremberg's focus on crimes against peace. And now I think for the very first time in decades, we once again hear international jurists calling aggressive war the supreme international crime. So this is just something that some jurists have prepared, an indictment of Putin. And yet this revival of interest in the crime of aggression returns us to a matter that was never adequately resolved at Nuremberg or in the decades since. Even after the definition of aggression was finally arrived at very belatedly by the International Criminal Court. Because in all the fraught definitional and jurisdictional debates involving aggression, one basic question I don't believe has ever been satisfactorily answered, which is, what is the purpose? What's the normative work behind the incrimination, behind criminalizing aggressive war? The crime of aggression, we should all note, it differs dramatically from our atrocity crimes, that is, war crimes, crimes against humanity, genocide. It differs dramatically in that it criminalizes not an offense against persons, but against states. For example, in the early days of Russia's invasion of Ukraine, the UN Secretary General, among others, condemned Putin for having violated the territorial integrity of Ukraine. If any of you were watching television over those weeks, you constantly heard people talking about the violation of territorial integrity. But what is territorial integrity? What is it? Except basically a restatement of the principle of sovereignty. And why should a state's violation of another's territorial integrity constitute an international crime? And from this perspective, the international criminalization of aggression looks a lot less like a radical rejection of this kind of traditional jurisprudence of sovereignty that we've identified at the earlier part of the talk, and it looks more like just another shield of protection. Within days of the outbreak of the war, I think we stopped hearing these concerns about Ukraine's territorial integrity because we started receiving all these reports of Russia's indiscriminate attacks on the nation's the Ukrainian nation's civilian population. So I think we can perhaps better understand the criminalization of aggression as a means to defend humanity from the scourge of war. But if this is the case, then it's not necessarily aggression per se that's the crime, but it's issuance in acts of atrocity. So this is a pretty revealing statement right here. And from this perspective, what makes Russia's aggression criminal is the fact that, like Nazi war making, it's being waged in the form of war crimes and crimes against humanity. So, for example, if Putin's attack on the Ukraine had been waged without these latter crimes, in the absence of war crimes, in the absence of crimes against humanity, I think the world would probably remain pretty mute about the former, namely its aggression. At least it certainly remains so in the case of his aggression against Crimea. Now, at Nuremberg, crimes against humanity, as we've said, were said to constitute an international crime only if linked to a war of aggression. And in the decades since, and now in the war of Ukraine, I would argue it appears that we have witnessed something of a reversal of that paradigm. It appears, I would argue, that aggression now stands as an international crime, that is, if it stands at all, only if linked to our trifecta of atrocity crimes, namely war crimes, crimes against humanity, and genocide. Indeed, I would argue that that probably was always the case. It was always the case, even back at Nuremberg, but only the fact that the extreme nature of Nazi aggression served to obscure this understanding. Now, of course, you might observe that all of this is utterly irrelevant in the case of Putin, given that it remains highly unlikely that the Russian autocrat will ever face any judicial reckoning with his acts of aggression / atrocity. But here, of course, we can't overlook a huge difference between Hitler's Verbrecherstaat and Putin's. Hitler's lay in ruins when the Allies staged their trial in courtroom 600 in Nuremberg's Palace of Justice. Putin's Verbrecherstaat remains unvanquished and presides over an arsenal of some 6,000 nuclear warheads. Now, this arsenal does not turn might into right, far from it, but it does, I think, expose the grim realities of those committed to bringing perpetrators of the Verbrecherstaat to justice. So thank you very much, and be happy to answer your questions. Yes, please.
Persecution, punishment of people for various kinds of acts, be they against humanity, against sovereignty. And I think it was a brilliant lecture. I really appreciate it. But I spent 35 years working on working on legal and political and even military hindrances to behaving that way. In other words, there is something which you didn't talk about very much, which is running parallel to what you've been talking about, which is the so-called rule of law post-war settlement, which began with, I would argue, with the United Nations Charter, began probably with the League of Nations Charter, but that was forgotten pretty fast, with the United Nations Charter. But then in the Western world, dictated mostly by American and British officials and jurists, there came to be a whole system which is still to this day in this country in particular called the rules-based system of international life. And the final conclusion of that was in the late 1990s when the NATO alliance was expanded, but at the same time I was one of the negotiators of it, we reached a solution or a settlement with Russia over how it was to behave in this new, peaceful, rules-based European world. And the European world was considered to be so central to it because it's the place, with the exception of Japan, which is a big exception, but is the place where the world got turned on end by the inability or unwillingness or determination of some countries to turn the existing order on end. And a word used in this country, as you know, hardly ever in the United States is the world order. And Americans don't like that. It sounds too much like McDonald's or something, but it's not used in America, but it's used here all the time. And so when we're talking now about Putin or talking about Saddam or other people, there is a whole body of non-legal, mostly non-legal, such as the Helsinki Final Act, the Charter of Paris of 1990, etc., which prescribe behavior to people, not to people, behavior by states, and they include the forbidding of all of the things that you discussed have not been defined, such as violation of national sovereignty, such as changing borders, such as undermining the economic health of a state, etc. All these things have been defined in really excruciating detail and are, in fact, in force. And it's interesting, of all of the agreements which were reached in the 1970s, in the so-called détente era, there's only one of them which is still in force, and that's the Helsinki Final Act. The rest of them have either been abrogated, overtaken by events, or simply ignored. So you see where I'm leading. The question is not so much, is there a legal debt to be paid here? Should Putin be brought before a tribunal? I think the general feeling in the world would be right now he should be. But leave that aside. There is, however, a sort of vision of society which has grown, especially in the Western world, which Russia signed on to, by the way, in 1997, 1998, and then has violated. It is a northern Western society sort of definition. We didn't care very much about it in Afghanistan or Iraq, to be very frank about it. But we care about it among the nations who make up the, what do you want to call it, the northern industrialized world. And I think this has been raised because the northern industrialized world wants to be rules-based. It doesn't want people running slipshod over things like Putin is doing right now. So where I'm heading is to say, I'm sure you know all of this, but how do these things now combine or compare or work with each other? Prosecution is not always necessary. Right. In fact, the United States won't allow itself to be prosecuted. Right. But at the same time, prosecution is always a tool behind the enforcement of these regulations.
Right. Yeah, I mean, the point that you raise is certainly a very important one, and I generally hate when academics defend their work by saying, "Yeah, well, I'm not talking about." I mean, so I think your point again is very well taken. I mean, I guess what I was trying to do, I was trying to look at a particular effort that I think found a very remarkable expression at Nuremberg, which was to kind of juridify certain categories and to really try to use international criminal law as a response to some of these world problems. But I think the point that you make is absolutely right. I mean, even if we point out, for example, that, I mean, I've suggested that there's something very problematic about the criminalization of aggression. Well, the fact that there's a problem with the criminalization of aggression doesn't then mean that aggression is legal. That is, there's a distinction between saying something is criminal and saying something is illegal. So I think we can certainly say, without any problem, and I think this is the force of the point that you're making, that aggression is an illegal act. And even the force of the international, largely, let's say, Western nations, that the force of the response, the kind of regime of sanctions that's been put in place, all of this reminds us that, that's a pretty potent response. Now, again, does that represent the success of the Nuremberg vision? Not really. But again, we can ask, I think, a very interesting question, which is something that I think international jurists don't necessarily ask frequently enough, which is you might say something along the lines of having an international criminal response to these kinds of atrocities is a necessary but not a sufficient condition to responding. But you could also maybe come along and say it's neither necessary nor sufficient, that maybe, again, we have these other tools at our disposal which are more efficacious and that actually suggest that the reliance on international criminal law is maybe simply just the wrong thing to use. It's basically kind of using a tool that was developed for the purposes of responding to domestic crimes, and it actually gets almost distorted, gets completely distorted when it's applied to the relationships between states. So I think that's a very helpful point. Thank you. Yes, there was, I believe, back in the...
When one sets, or a community sets, principles, the credibility very much depends on that you obey to those principles. And there's another word we haven't used this evening, and that was invented over the last years: responsibility to protect in Kosovo. Is the consequence, well, there is a responsibility, but not if on the other side stands a country which possesses nuclear weapons. And what are the consequences? If we would apply this principle also to our domestic world here in Berlin, we all hope that can we rely on the responsibility of the state, that if my individual rights are affected, that police or the state will defend my rights, but not if on the other side stands somebody who has connections to a ethnic mafia, which then I'm afraid that they have their means to make sure that I don't even have the courage to rely on my rights. So it has huge consequences if he applies this, if this principle applies no longer generally. And how do we cope with that from your point of view?
Is everyone familiar with this kind of this R2P principle, this notion of responsibility to protect? I mean, it basically is, I don't want to be necessarily cynical, but I think it's a recasting of the idea of humanitarian intervention. And I think wars of humanitarian intervention, people didn't like that term particularly. It sounded very aggressive. It sounded perhaps the notion of imposing American hegemony elsewhere. And so they kind of repackaged this notion, the UN, people in the UN kind of repackaged this notion of humanitarian intervention into this notion of responsibility to protect. And in a sense, it emerges a little bit of what we described when we looked at the Genocide Convention, this idea that the world community is not supposed to stand around and let a sovereign state commit atrocities against its own legal subjects. At the same time, this business of intervening to stop these things, it sounds good. It sounds lovely, but it is a whole lot more problematic when you actually try to work out the details of something like that. Because again, what we're back to, it's a little bit about, I hate to quote Schmitt in his response to Kant, but it's basically, you're back to waging war for the purposes of stopping atrocities. And is that justified? Well, maybe that is justified, but it really raises a huge number of very complicated issues. And, obviously during the Clinton administration, the Clinton administration got very bad press when the State Department refused to use the word genocide to describe what was unfolding in Rwanda in the spring of 1993. Why were they reluctant to use the word genocide? Because once you use the word genocide, it creates all this pressure to intervene. And suddenly the United States looks terrible because it's failing to intervene. It's failing to kind of use its military force for the purposes of saving hundreds of thousands of imperiled civilians. But the idea that you just go into a country and stop genocide like that, it's not a simple thing. And you are talking about war, and you're talking about casualties, and so I find the whole idea incredibly problematic. So it's not simply the idea that, oh yes, well we intervene when it comes to Kosovo, because there we can kind of engage in an air war, but when it comes to Russia, we don't intervene because they have nuclear weapons. Well, sure, that's true as well. But you should also notice that even in our intervention in Kosovo, in the 1999 air war over Kosovo, Russia said that's a paradigmatic example of aggression that's forbidden under the UN Charter. And so even that was kind of turned around as an example of like, that's not humanitarian intervention. That's actually a war of aggression itself. And so these categories, they become incredibly fraught and problematic. And, even kind of repackage as something like R2P. And I don't want to be cynical of it because obviously we don't want to stand around, as I said, and watch atrocities take place. But the idea of that there's a simple solution and the only thing that stops us is when a country has nuclear weapons, I think that's not the case. I think the politics of intervention are incredibly fraught. I could even go into kind of greater detail about that if you want, because I think when you engage in this kind of intervention, it starts to, in this larger book that I'm writing, I try to talk about the way some of these interventions, they erase the distinction, which is a pretty foundational distinction in law, between war making and policing. Now, last week, Lauren Benton showed us how in the colonial context, the distinction often does erase. But when you start getting in these things like humanitarian intervention, the distinction between policing and war making becomes very fraught. And the norms that apply, whether the ordinary norms of armed conflict now apply in that situation, it's not clear at all. And once the laws of armed conflict start to be relaxed, then suddenly you're opening yourself up for potentially really bad things happening on the battlefield. Again, if that's too technical, I'd be happy to go into that in greater detail later. But I appreciate the question, but I do think the issue is very, very complex and really heart-rending in many ways. Other questions? Oh, come on. Come on. I knew Lauren was going to. Yeah.
So you'll forgive me, I hope, for seeing empires everywhere.
Yes.
But I appreciated your bringing up this question of quasi-sovereignty, which really absorbed international lawyers, as you know, at the end of the 19th century. And some people portray it as just a moment that then passed, that they paused to consider what they would do about quasi-sovereign polities inside empires that had some of the marks of sovereignty but not others, and they clearly didn't fit within an interstate order, and so there was sort of back and forth about what we would do about them. But then, in some accounts, this is just a moment that is then over. But in some ways, and so I wasn't quite sure why you were bringing up quasi-sovereignty in this context, but then I thought, if we consider the observation that many people have made that Putin's perspective is really driven by an imperial perspective about what he's doing. It does strike me that, in effect, it seems entirely wrong from a Western perspective, but in effect, he's arguing that the Ukraine is not a state, right? That it's a quasi-state, that this is not an act of aggression because it's either a quasi-state because, he made that slightly mad excursion into the history of its creation, but also I think he's implying it's a quasi-state because it's beholden to the West. And so, in effect, it's in an imperial sphere. So, I mean, this is more a comment than a question, but really I wanted to know, is that where you were going with this when you brought up quasi-sovereignty and Lorimer, or am I missing some other connection that you were trying to make?
Yine. So I think is the short answer. So actually, the connection that I was really trying to make was at that part of the talk. I mean, I think one of the things that Jaspers was saying when he talks about the Verbrecherstaat was this idea that it's a rupture with Western history. That this advent of this, and I was just basically trying to say, like, well, that's interesting. We had an episode of genocide some 30 years earlier. Why did that earlier episode of genocide not occasion a rupture? And I was thinking, and the answer I was giving is, again, you have to understand that this whole notion of statehood was not being applied to some place like Turkey. The notion of this kind of close association of civilization and statehood, which was so central to this Western legal order, there was this kind of like anomalous position for entities like Turkey. And so at that point, that's all I was trying to do. I was simply trying to explain why it was that there wasn't this kind of sense of rupture with the Enlightenment tradition when you're dealing with another episode of state-sponsored mass extermination. And how, in fact, that episode of mass-sponsored state extermination, in sense, it confirmed many of the assumptions that were built into this Western legal tradition, namely this idea that only in the West are statehood and civilization united in this kind of meaningful normative whole. So that's really what I was trying to do with that point. Though, again, the thing that and again, maybe this is just a kind of a free associative response just to kind of go with where you're going, which I thought was very, very interesting, is I did think that one of the things I'm trying to write about right now is the way in which once the Nuremberg model of focusing on aggressive states starts to, lose traction in the decades after Nuremberg, one thing that starts to replace it is this notion almost of failed states. And failed states starts to move in this direction of semi-sovereigns. This idea that, again, it doesn't necessarily apply to Ukraine, but this idea that they're not really in control of their territory. And because they're not in full control of their territory, then that becomes an opportunity, a reason for intervention. So again, that is a kind of almost maybe a resurrection of some of these of seeing empires everywhere. So, yeah. First in the Adi. Yeah.
Thank you, Lawrence, for a great talk. This was not really the purpose of your talk, but I would be kind of curious where you think the enterprise of international law stands right now. So you basically posited two options. One is that Nuremberg, a focus on aggressive war and the crime of aggression as for the purpose, and then the purpose of genocide. And it just seems that whichever way you go, it's kind of been a failure, arguably. I mean, certainly on the issue of accountability, one could hardly argue that there's been accountability for the many war crimes that have atrocities, genocide that have taken place over the last 20 or 30 years. And it doesn't seem to have deterred anything if you look at what's happened in Syria with the Rohingya or now with Putin. So I'm just wondering where your study of international law leaves you thinking about the effectiveness of international law as a source of accountability and deterrence, and what you would do to strengthen that. Because we all want to live in a world where the rule of law exists, but it seems that we are sadly drifting away from that now as opposed to getting closer to it.
Yeah. We can always say that with international criminal law, it's always fair to say, well, do we see the cup 1/10 full or 9/10 empty? So maybe I'll, right now, just to say it is 1/10 full. And I do think, though, that, very often if you read the documents that are issued by bodies of international law, if you look at the Statute of the International Criminal Court or any of the documents associated with the Yugoslavia, the Rwanda Tribunal, they'll always talk about deterrence. I think if you actually talk to a lot of international criminal lawyers, they basically, they almost wink at you, like no one really believes that they're going to deter anybody. So I think in certain ways, deterrence this goes back to my response to your question, which is, criminal law is something that is imported from a domestic context. In a domestic context, concepts like deterrence have some bite. They don't necessarily make a lot of sense when you try to then apply them to the international context. Now, does that then mean that the effort is a worthless one? And I think the answer is no. I mean, I think with regards to the question of accountability, clearly only a small fraction of people who have committed atrocities in the most recent decades have seen any kind of legal reckoning with their acts. On the other hand, this was something I was talking about at dinner. I do remember, and this might also be relevant when we think about the future for Vladimir Putin. I do remember in the early years of the Yugoslavia Tribunal that many critics said, what is the point of spending all this money if we're just trying these little fish? We have this tribunal. It's never going to get Slobodan Milosevic. It's never going to get Radic. It's never going to get Mladic. And it ended up getting all three. And, that's a pretty dramatic and impressive success. And, the other thing that I've tried to write about in some of my work is the way in which accountability also means like creating an account of actually creating a kind of a document that establishes an evidentiary-based report of criminality. And I think it's very important to have that kind of evidentiary-based report of criminality, and that it helps to kind of clarify in the minds of the public exactly what has happened. Now, again, can it be politicized? Obviously. Is one thing that interferes with the international rule of law the fact that, nations such as the United States has refused to join the International Criminal Court? I mean, we've had this very, lurking relationship to the International Criminal Court, having, times of cooperation, then followed by times of, outright hostility, and now back to a time of relative cooperation. I look forward to the time where the United States would join the ICC. I mean, the United States was the prime mover behind Nuremberg, was the prime mover behind the Yugoslavia Tribunal, and I think that would be, an excellent thing if the United States were a participant in this global effort to establish justice for the most extreme crimes. But I don't think anyone can really go to sleep going like, yeah, that's working great. But again, this is why I think almost when we use this model of criminal law that's imported from a domestic context, we have an idea of what justice looks like. And I think when you place that in the international context, you almost have to just redefine what you mean by justice. You just cannot use the same metrics for defining success and failure. And I think some of the successes really have been, impressive enough, even though, again, I think it is important to kind of recalibrate the metrics that we use. I think Adi was next, and then Mr.
Thank you, Lawrence. It was fascinating. I want to return to the phrase with which you started by Jaspers. This is a criminal state. The Nazi was a criminal state. And I want to think about it for a moment slightly differently. When I read this, when I'm hearing him saying this, I think that the basic thing that he wanted to say is this regime should not exist, should not have existed. Mm-hmm. And so I think it's better to speak here about regime and not a state. It would be more accurate. It's the non-existence of something like this which is at stake. Now, the law is one way to do it. Military force is another way to do it. But there are other ways to do it, or to think about it. How we bring something like this into non-existence. So I think that in the case of apartheid, it was quite clear. There was no war. It was clear that this should not exist. And the boycott became a tool. So why? What would happen if we think about types of regime that should not exist? That would include everything that the Indian lawyer justice that you mentioned wanted to introduce into the story, of course. And once you declare as a regime as somebody that doesn't worth the right to exist, then anyone who deals with it, who does any business with it, should be boycotted as well. I think we see something like this in the way NATO and the West, so to speak, deal with the Russia today. Mm-hmm. But just it's just half of the work. It's not really complete cutting off of all relation. But then maybe the law could be used in order to enforce in situation like this. Instead of speaking about international law, speaking about domestic law. If you are part of a treaty that defines regimes like this as regimes that have to be thrown out of existence, then you could enforce certain behavior of the citizens of this or that state and cut ties with this regime. So I think it's a shift of, it's not international law and military intervention. It's domestic law and civil activism.
Yeah, I mean, I'm not sure if you hear, John, similarities with Adi. I mean, it sounds as if there are some similarities with the point that you're making, Adi. I guess maybe I should also point out that even when you're talking about, let's say, things like apartheid, the apartheid, the overcoming of the apartheid regime, there was, of course, there was a very important legal component to that as well. I mean, it manifested itself through this sort of quasi-legal response in the form of the Truth and Reconciliation Commission. And, obviously when we're talking about efforts to, let's say, transition from autocratic regimes to democratic regimes, we can think of all sorts of, is the criminal law, again, a necessary condition? It's not necessarily a necessary condition, but it's one alternative. Is something like a Truth and Reconciliation Commission something that's a possibility? Yes, that is. And for those of you who are familiar with the Truth and Reconciliation Commission, this was a body that basically was not a criminal legal body. It was basically a body that conditioned amnesty to perpetrators in the apartheid regime on their willingness to offer a full disclosure of the kind of acts that they engaged in. And whether that was a truly successful effort, again, we can start getting back into like these kind of arguments about R2P. I'm not convinced that the Truth and Reconciliation Commission was as successful as many people think it was. But I think the point that you're raising is an important one, that there's a whole panoply of responses that one can contemplate for the purposes of trying to make that transition. The other thing that, again, I don't want to, it's a kind of a fool errand to to engage in a kind of creating a hierarchy of what regime is worse than what regime. But I don't think if you're dealing with a kind of an exterminatory kind of state that Jaspers is talking about with regards to the Third Reich, that something like what happened with South Africa is remotely possible. I do not think that you can find any kind of internal shift that's going to see that sort of transition. And again, we might be in heated agreement about that. That might be something where it is necessary to have some type of, external intervention for the purposes of, to use the language that you're using, have this regime no more or to stop it. But I do think that the South Africa example, and even having something like a Truth and Reconciliation Commission, I don't think you can imagine something like that in the wake of exterminatory genocidal acts. I don't think you can have truth commissions in the wake of genocide. I just don't think that would work. And even the Truth and Reconciliation Commission, again, in terms of the rhetorics of these things, you should pay attention to, truth and reconciliation. It's like, what makes us believe that reconciliation follows the telling of truth? It might actually be what follows me hearing you talk about the atrocities you committed against my family. It doesn't lead to reconciliation. It leads to my sense of frustration, hatred, and rancor. So, just, I'm getting signals that I have time for 20 more questions. So, in the back. Oh, yes, over here.
I'm a business lawyer, so maybe I have definitely only an outside.
I'm always wary about those kind of questions. Okay. Always wary about questions. So I'm just an outsider, and then I'm sorry.
That's true.
Yeah.
But I'm a civil. I like civil service to a certain extent, and I think for NGOs like Human Rights Watch or Amnesty International, it's very, very important to have global or international standards which connect them those concerned by the atrocity on the place with those who can detect these atrocities. And for that, I think a global view as international criminal law should give is, I think, very important also to channel those who are dissatisfied in their own countries with the situation, and then they have a sort of possibility to reach out to other countries. And in that respect, isn't there at least a need for international criminal law? Even if I learned today rightly, it seems almost impossible to define it.
Yeah, I mean, I think that's, again, I think that just reminds us about the way in which maybe we just need to change our metrics when we're trying to evaluate the success of something like international criminal law. I mean, if you're dealing with domestic law of something like someone who's accused of murdering, like naming and shaming doesn't sound like a particularly efficacious response to someone who's engaged in murder in a domestic context. That would seem like an absolute failure of domestic law if all it does is issue in a naming and shaming. In the international context, maybe that is an important success. That is something with that to the extent that we kind of, again, establish, let's say, a baseline record, and even if we're not able to bring charges against someone, if we're able to, for example, turn them into an international pariah, to turn them into someone who has to be very cautious about what airplanes they board and have to be cautious about where they're landing, lest they possibly face some type of prosecution based on a theory of universal jurisdiction, like we saw trials, a couple of trials in Germany that my colleague here, Deb Amos, is going to be talking about. So I think I agree with you, and certainly the work of these NGOs is it's very valuable work, and it obviously it's very valuable also in that it I think one of the things that is the upshot from this talk is the way in which even with all politics, with all law, politics informs law. But when you're dealing with something like international criminal law, it's really hard to, the level of political interference is very, very high. And I think one of the important works that NGOs do is it's not, I think it would be naive to think that NGOs don't have their own political agendas. And yet I do think it is important that they at least relatively, they can somewhat insulate themselves from the kind of political agendas that we see other political actors responding to. We have time for one more question, so
yeah, I'm the lucky one. I'm also not a legal scholar or lawyer, so that the question might be a little bit naive. You mentioned that the Armenian genocide didn't cause any rupture because Ottoman Empire was not part of the, let's say, Western normative world. But I'm thinking, like, what about the crimes in the colonies or colonial crimes? Did they play any role in forming the, let's say, definitions like crimes against humanity or international justice, or when did they become part of that discussion?
Well, again, I would I would defer to Lauren to really answer that question. I think it's fair to say that, you have records of, let's say, atrocities that are being committed by the British. They make blue books, these official governmental reports about atrocities that are being committed by the Germans against the Herero people. You flip it around, and the Germans immediately, they create their white papers on atrocities that are being committed by the British. Anyone who's read about the kind of things that King Leopold did in the Belgian Congo, their immense legacy of there's a lot of atrocity that's going around. I think it's fair to say, and again, my colleagues might disagree, I think it's fair to say that, again, those type of patterns of atrocity were almost, again, this is sort of a gross simplification, but I think, again, they were dismissed as excesses of a civilizing project. They weren't necessarily, again, seen as a kind of rupture in that project itself. It was seen as, this project doesn't apply well in certain contexts. In certain contexts, norms are relaxed, or different norms apply, different laws apply. So the laws that might apply and regulate the relations between these Western states don't necessarily apply in this colonial context. And again, I think one of the things that you find in the colonial context is the way one of these prerogatives of the sovereign, namely that I have control, I have monopolistic control over the treatment of my own subjects, that understanding applied in imperial context as well. And that, in a sense, also shielded coordinate sovereigns from basically engaging in legal reckonings with their neighboring states. Is that okay? No. She says no. No, I'll take that as a no. So anyway, I think this is where we, on that very positive note, I think this is where we say Gute Nacht. Gute Nacht, schlaf gut.